I want to make sure I heard you right. So you're paying child support for a child who lives with his mother and his biological father?
Yes,
Is that
sir.
what I heard you say?
Yes, sir.
Okay. Thank you. I just wanted to be sure I heard that right.
During the legislative sessions of 2014, 15, and 16, attempts were made to change Washington law to allow a man to petition a court for the termination of all legal responsibilities of parentage if DNA evidence showed he is not the genetic father of a child. Among the 5 bills attempted, none ultimately passed. But public hearings were held for each bill. Men told their stories, and interesting arguments were presented. This video shows the strongest arguments for and against the proposals that people gave during those hearings. In this video, we show highlights from the 3 hearings in 2014 and 2015, and in a companion video, we show highlights from the 2 hearings in 2016. We start now in the Senate Law and Justice Committee in 2014 with a public hearing on a bill sponsored by Senator Jan Angel. First, a neutral staffer to the committee explains the bill.
Good afternoon. My name is Tim Ford, Committee Counsel. Senate Bill 5997 concerns the termination of all legal responsibilities of a non-parent if genetic testing shows by clear and convincing evidence that a man is not the genetic father of a child. Under Washington's Uniform Parentage Act, a presumed parent may challenge the parentage within 4 years of the child's birth. Genetic testing is admissible in a proceeding to challenge parentage. Genetic testing may be allowed or, alternatively, denied by the court where it is not in the best interest of the child. A man excluded as the father by genetic testing must be adjudicated not to be the father. Senate Bill 5997 provides a right to challenge parentage if genetic testing shows by clear and convincing evidence that the man is not the genetic father. Genetic testing is presumed to be in the best interest of the child. A court may not deny genetic testing if a presumed father did not know that he was not the genetic father. And a man who successfully challenges parentage must be discharged of all legal rights and duties, including the payment of child support.
I'm Senator Jan Angel from the 26th District, and this is a bill that it's not just 1 or 2 constituents, but constituents from not only my district, but as this bill has come forward just in the last week or 2, it has affected so many people's lives that I'm glad we're finally going to have the discussion. I could tell you story after story, but the one story I want to convey today is that when a man has found out that the child through genetic testing is not his child, he has no recourse. And if he has gone on to perhaps have a second marriage and natural children, which are his children, then it affects how he is able to provide for his natural children. And this would provide recourse that he could at least then come to the courts, show the genetic testing, and have the option of being able to get out of that. Does this mean we don't care about children? No, not at all. But we must look at the facts and the fairness and the equity of this.
Have you considered the difference this makes to the child as opposed to the difference it makes to the father?
The father would have to petition the court for this process to take place. You know, there may be a situation where even with the genetic testing, he may not choose to. But if he did choose to petition the court, at least the process would be in place.
My name is Brandon Jones, and I'm personally affected. My family is personally affected by this law and the flaws that are in it as it stands currently. Went and had a DNA test done. It turned out that I wasn't the father. Between the mother and I, we decided that it was in the best interest of the child, since I really didn't have much of a relationship with him anyway because of some of her actions. The best course of action would be to go ahead and just eliminate the entire relationship and just be done with it. We went to court. With her being on TANF, I had to serve the state as well. The mother didn't fight against me on this. The state did. And their justification was, well, if Mr. Jones isn't paying child support, who will? My answer to that is, how about the biological father? And I believe this law actually addresses that and says that it's important to establish the parentage. The child that I thought was mine was admitted to the hospital right after he was born. I gave my medical history for that child. It didn't really affect him too much because I don't have any major illnesses or anything that would have genetically transferred over to him. However, my biological son was admitted to the hospital after he was born, and I gave his brother's medical history for my biological child. And so they actually started going the wrong direction in trying to figure out what was wrong with my son, and it delayed treatment for him. Luckily, he made it through everything just fine, but he had a bunch of unnecessary medical procedures because of the information that I gave for a child that wasn't mine.
I was 19 years old when my girlfriend claimed to be pregnant with my child. I had no reason to believe otherwise. 4 years ago, I found out that that was a lie. This lie changed the course of my life. This one lie ruined my life. I had young dreams of going to college and continuing my music career as a bass player. I dreamt about traveling and enjoying my youth. But instead, I abandoned my college and musical dreams and began to work in construction to care for this woman and what I thought was my child. This woman has filed in court and succeeded in raising my child support 3 times over the last 4.5 years. I am responsible for 82% proportionate share for the financial support of a child I do not have a relationship with while her mother works part-time. It is becoming increasingly difficult to provide for my own children because of this child support obligation. I'm tired of telling my children I cannot afford to pay for things like swim lessons, ballet lessons, or any extracurricular activities. It is depressing that I hate my job and want to be able to change careers but can't afford to because I have to keep making money to pay a woman who is getting away with perjury and fraud against me.
My husband, Andrew Evans, is a victim of paternity fraud. 14 years ago, my husband's ex lied to him and declared under penalty of perjury that Andrew was the father of her child. So by the time my husband found out the truth, he's helpless to file any challenge in court and is currently being forced to pay $850 a month for a child that is not his. I've heard some different people within the legislation say that some lawmakers may be unwilling to support changing the current law due to the potential loss of federal subsidies. Title IV, Part D, federal subsidies provide incentive money to our state for the collection of child support. And I want to believe that our lawmakers would not support an innocent man being defrauded for the sake of money. I have suffered through years of injustice, so you'll have to understand when I say that I want change now.
In October of '98, I was served with notice from the courts in Washington that I'd been named as a putative father. I submitted to a DNA test the very next day. At that time, my law said we had 90 days to do that with. It took 87 days for me to get the results of that test back. And even though the Spokane County Court had my test results, it was still preparing to press a support order against me for a child that its own test showed wasn't mine, simply because the mother wouldn't tell them where the actual father is, and even after I told them where the actual father was and where he was. When the wrong man is named by the court, the first result of that is that the child's actual father has just had his child taken from him by the state without a finding of unfitness. This is very wrong, especially when it happens in the face of a DNA test that shows the error. At the same time, the child is denied a relationship with its actual father or even knowing who he is. Today, 15 years after my experience, I would like to say that things are better, but I cannot. If you refuse to pay a support order today for a child that you can show is not yours, your license is suspended, you are arrested, and then you are jailed. Whether through mistake, omission, or outright deception, when the incorrect person is determined to be the father of a child, there is still no legal remedy. Senate Bill 5997 provides that remedy by allowing the wrongly named father to terminate such a finding and allows the court to name the correct person as the father of that child.
Senator Klein's question is gets to the heart of this. We've heard testimony from folks who have been, unfortunately, poorly represented by the law. Perhaps we haven't heard about the children in those cases. But I want to say that any law in family law or probably any other area is going to have some bad facts, some bad cases. And that's what I call the bell curve. We don't want to pass statutes that take care of people on the edge without taking care of the general people. Under current law, fathers or alleged fathers have 4 years from the birth of the child to challenge paternity. That should be plenty of time. And as Senator Klein pointed out, in these other situations, we may have a child who thinks of this person as the father thinks of this person as the child for years on end. And under this law, now what happens is if he finds out that he's not the father, he can come and challenge and overturn that. That can be devastating for the child. And what we look at more is from the child's point of view rather than from the father's point of view.
My name is David Ward. I'm an attorney at Legal Voice, an organization that works to advance women's rights in the Northwest. Parentage issues are something that we've paid a lot of attention to over the years, including the most recent revisions to the UPA in Washington that were passed in 2011. That legislation did extend, actually, the period where a paternity determination could be challenged from 2 years to 4 years. So there already has been significant movement in Washington to give a fair opportunity for folks to challenge paternity determinations that they believe are wrong. In fact, we do have a longer period of time than most states, I believe, and we also have a longer period than is recommended by the model UPA. We do believe in making parentage determinations. The interests of the child have to be at the center. We need a child-centered approach to this because the child needs support, the child needs love, the child needs to have somebody, ideally more than one person in many cases. And what this bill could do is result in a lot of children losing people that they've known their whole lives as a parent through no fault of their own, and could leave them without support they need. And finally, I just would also like to say, we do not look solely to biology in determining if somebody's a parent in Washington. Obviously, the genetic component can be important, but it's not the only way we determine whether somebody is a parent. Acting as a parent on a day-to-day basis, establishing a parent-child bond is important, and it is also another way that paternity can be established in Washington.
I'm having a hard time understanding if the bill increases the ability of DSHS or DCS to find the genetic father, and if not, are we going to wind up with a bunch of children who basically have no financial support and are going to wind up depending even more on the state?
The bill does not provide that the biological father will be identified. It can leave a child with one less parent and not with no assurance that the biological parent will be identified.
There was one other individual who signed in not wishing to testify but opposed, Carrie Morris from Equal Rights Washington.
Next are highlights from 2 hearings in 2015 on similar legislation. We'll hear some new voices as well as new points made by some of the same speakers from 2014. Note that in the first hearing, the camera is at the back of the testifiers, but in the second hearing, we do go back to being able to see the testifiers' faces.
Senate Bill 5006 concerns the termination of all legal responsibilities of a non-parent if genetic testing shows by clear and convincing evidence that a man is not the genetic father of the child.
This bill is probably at the very top of my list for priorities for fairness. This bill over the interim and since last session has probably brought the most comments from all over the state, and I didn't realize what a big issue it was until we heard from so many fathers and gentlemen that thought they were fathers. I got a call from Vancouver, Washington, where a man stated that he was not the birth father of the child, but he had no way to go to court to rectify that. He had found the birth father of the child who wants to be on record as the father, and the two of them are in agreement of getting that done, but yet there is no means for them to do that.
I don't want to overreact, but I think it could be an historic opportunity to stop an ancient injustice. Paternity fraud goes back a long time. You know, even in Greek mythology, the goddesses were ashamed of it. I have met victims of paternity fraud. I got to tell you, it's a sad, sad story. These are totally innocent people, and frankly, they're appalled, rightfully so, I think, that they're being forced to pay for somebody else's kid. States are passing laws that allow DNA evidence to overturn child support orders. Maryland passed its like 20 years ago.
I'm one of the many victims of paternity fraud in Washington State. In my efforts to address my concern, I have had a conference board, modification hearings, and appealed directly to the DSHS through my support enforcement officer and the courts. All of my efforts to get a resolution in this matter have been denied at every avenue. I've worked very hard to put myself in a position to earn a reasonable wage that I can support my family with. It is very disheartening to know that my wages can and are still garnished even though I have a DNA test from an accredited lab proving that I am not the father of the child. I also have a letter signed by the child's mother addressed to the DSHS informing them that we did DNA testing and the child is not my son. This letter also states that it is her wish and intention that my name be removed from her son's birth certificate and all collection of past and current child support ceases. Even with this letter and the DNA test, my appeals to the agency have been denied. I've been overlooked for several highly skilled jobs because of the negative connotation of $20,000 in back child support. I feel disenfranchised, like a criminal on the run with a conviction hanging over my head for a crime that I did not commit. It is disheartening in the day and age where DNA evidence can overturn a murder conviction and get someone off of death row, yet it cannot free a man from being held accountable and charged for someone else's child.
I'm not going to go back into my story. I told it to you last year. I know as well as many others do that it doesn't take biology to be a parent. There's something special about knowingly taking the responsibility of parenting a child that you have no biological connection to. Whether they're adopted or step-parenting, the person taking responsibility knows they are not that child's biological parent. In addition, in each of these non-biological cases, the child has access to information about their biological parents and their family. They have access to information about their health care, about their health history, and about who they are. The state of Washington found that it was good for adopted children to have that access to that information and passed a bill recently that allowed adopted children to have access to that information. Children who are victims of paternity fraud do not have access to that. I'm sure that you're going to hear of the possibility of just some sort of mass bastardization if this bill passes. There is no evidence that shows that anything like that will happen.
I want to address some of the primary concerns I've heard from legislators. The first being, who will pay for these children if victims are allowed their freedom? And I think it's important for legislators to first recognize that forcing a man to pay for someone's deception is fraud. That being said, the answer is simple. The biological fathers can pay for their children. There are laws in place that allow the state and mothers to reestablish paternity at any time. There's no statute of limitations on this. I understand there's a concern about children losing father figures. I think it's fair to ask why these men would not be allowed a relationship with a child if they weren't forced to pay for them. Family members like grandparents, aunts, and uncles are not required to pay for their role in a child's life. And if these mothers were truly remorseful for misidentifying their child's father, there's no law stopping them from allowing that relationship to continue, even after termination of legal obligation. It is just as important to consider the biological fathers whose children were kidnapped at birth. It saddens me that legislators overlook these men as if they don't exist, and I think many underestimate these men wanting to have a relationship with their child. I think it's foolish to underestimate biological ties in general and a person's instinctual desire to know and be a part of their heritage. I'd like you to think about how many people's lives have been destroyed, all for the sake of money. And I ask that you consider the best interests of my children, whose financial deprivation continues to be ignored. And I ask that you pass this bill so that I don't have to deprive them of one more second of my time, pleading with you to do what's right.
My story is really, really simple. After 13 years for caring for a child and considering my own, I found out on December 23rd, that's right, 2 days before Christmas, that he is not genetically connected to me. This is not only financially devastating, this is mentally devastating, physically devastating. This has been so hard on my marriage, so my wife has had to pick up the emotional baggage for somebody else. I cannot begin to explain the frustration that this has caused. And once we agreed to go to the state to present the situation, I found out that I had zero support from the state in regards to sympathy. And they just told me, well, since you've been paying, we're just going to keep it going, and why would we stop? Now, I would like to address the issue in regards to leaving kids fatherless. This is my son regardless. After 13 years, I would not stop loving him. I will always be there for him. But do I feel like I need to be financially obligated to this child? No. It should either go to the mother of the child until she can figure out who the real biological father is, in which I'm pretty sure once she figures out any past and present debt has been passed to her, she will definitely cough up the name of the real father of the child.
My name is David Ward. I'm an attorney at Legal Voice, an organization that works to advance women's rights in the Northwest. And I was also here last year testifying on this bill. We take a different position and we do not support this legislation. Most recently, the legislature amended our Uniform Parentage Act, our version of the Uniform Parentage Act in 2011. And when we amended the law, I think we struck the correct balance on issues like this, taking the view that our parentage laws are designed to promote certainty and security for children in who their parents are. That's why the legislation that was passed in 2011 provided 4 years, up from 2 years before, for a man to challenge his paternity, whether he voluntarily acknowledged paternity when a child was born to unmarried parents, or whether the man is a presumed parent as a result of being married to the mother of the child. And I think this strikes an appropriate balance of creating certainty for children.
Just trying to understand your position, you're addressing primarily the emotional tie, the emotional relationship, and the need for children to have certainty who their parents are in that respect. Nothing here, I think, would prevent this gentleman who just testified, for example, from continuing on, as he said, to be a father to that child. We're just talking about the financial aspect of this. And then when we've discovered who the right parent is, they could certainly go to that parent, the correct parent, and get the financial assistance.
With all due respect, I mean, we do believe that duties and obligations of parentage can't necessarily be disaggregated in that way. They are responsibilities as a parent to provide all the duties and responsibilities of a parent once you've had the determination made that you're a parent. And often these are through voluntary acknowledgments of parentage when a child is born. There's no obligation to sign an acknowledgement of parentage. And when you sign that, you are agreeing to take on the responsibilities of a parent for the child's life, and it's a big deal. And appropriately, our state does, tell people when you sign an acknowledgement of paternity that is what you are. You're agreeing to be the child's parent with limited ability to challenge it after a certain period of time.
Right, but if the parent signed that acknowledgement under a fraud, if the parent acknowledged paternity and responsibility, believing themselves to be a parent. I understand that, but a longstanding principle of common law that dates back, centuries is that if a contract or an agreement is induced by fraud, it's unenforceable.
Well, another principle of common law that goes back years is that a man is presumed to be the parent of a child who's born to his wife. In these situations, again, I think it's up to the legislature to decide, obviously, where it wants to strike the balance. Even under our current laws, the courts do have equity to decide it's not in the best interest of a child to do genetic testing to determine who the genetic father of the child is. And this bill would take that away.
Once a finding of paternity is made in error, no matter the circumstance, as honest mistake, a presumption, or an outright deception, there's little you can do. The subject matter at hand is removing a child from an actual father without a finding of unfitness and forcibly adopting it to someone else for financial gain. Under international convention, the International Convention on the Rights of the Child as part of the UN Charter, that's considered a human rights violation. For the state to hold you liable for actions you are not responsible for, did not facilitate, participate, a party of, or even know about, requires a suspension of due process and is also supposed to be unconstitutional. The objections raised on this bill all seem to fall under the same category, that the ends should justify the means. It doesn't matter how an order is put in place, it doesn't matter against who, but once it's there, we shouldn't allow anything to be done about it. The ends are never supposed to justify the means. That's why we have the rule of law, and that's also why we have an appeals process, because mistakes can and are made.
As a formal paralegal, I'm here to testify in support of this bill because I watched the hearings last year and I was disturbed with some of the assumptions that were made. And then also I felt like the presumed fatherhood issue wasn't identified and wasn't reviewed at all. So in addition to my testimony, I'm submitting testimony from someone who wasn't able to be here that goes through the issues during separation and divorce of presumed fatherhood. So from the hearings last session, I noticed that many legislators raised questions when they heard from people in the legal community that we wouldn't want to change a law simply for a few people that this had impacted. Contrary to their belief, it is a frequent problem. Another concern that the child would lose a relationship with this father if paternity was established. As should be obvious, children have multiple relationships with people in their lives that do not financially support them. If the mother has the best interest of the child at heart, she'll actively encourage such relationships, regardless of whether or not she is paid to do so. Also, the idea that the child will not have support because this particular man is not providing it is not how the system works at child services. In order to receive support services, the woman will have to produce a father, and it will be in her interest to produce one.
1524 establishes a process for a man to bring an action to challenge paternity and remove associated rights and responsibilities if genetic testing demonstrates that the man is not the child's genetic parent. Under the provisions of the bill, a man can file a petition in Superior Court to rescind an acknowledgement of paternity, challenge a presumption of paternity, or contest an adjudication of paternity if genetic testing shows by clear and convincing evidence that the father's not the genetic parent of the child. From the date of the filing, the man's discharged from all of the rights and duties of a parent, including any obligation to pay child support. These actions to disestablish parentage on genetic evidence can be brought within 2 years of the date on which the petitioner becomes aware that he's not the child's genetic father. And the process does not apply if the man's the adoptive father or consented to assisted reproduction. Additionally, the court can't deny genetic testing in a petition to challenge paternity if the presumed father didn't know that he was not the genetic father. Finally, the bill creates a presumption applicable in other parentage adjudications that genetic testing is in the child's best interest. The presumption can be overcome by clear and convincing evidence that determination of parentage is not in the child's best interest.
This is a problem that came to me throughout the last year, where I had many constituents who had said that they had thought that a child was theirs, or maybe that they were on leave, because I'm from a military district, and then they came back and were responsible financially for taking care of a child that DNA proved was not theirs.
I remember the day that my child was born like it was yesterday. I was overwhelmed with joy, happiness, and pure bliss. So many thoughts ran through my brain in regards to what I can do to be a better man, not only for my child, but also to the woman. Never once would the idea of a DNA test ever enter my mind. 2 days before Christmas of 2014, I got the results of a DNA test stating that I was not genetically connected to my son. I want to state there is nothing that would ever stop me nor deter me from being the father in his life. This is the only son I know, just like I'm the only dad he knows. So therefore, I will always be there for him. Do I plan on buying his first car? Yes, I do. Do I plan on helping him with his first prom and limo ride? I do. However, I do not feel like I should be financially obligated to these duties, seeing how I am not the biological father.
My name is Carol Fountain, and I'm here today because one of the people here is my son. I'm kind of upset about this because as a single parent, I work 2 jobs. I got up at 2 o'clock in the morning. I walk to get on a bus to be to work by 4 o'clock in the morning. I get off work, I go to work, I go back to work, and get off work till 8 o'clock at night. I did that to support my kids. Now I have a son who has a son that is not his. I taught my son how to be respectful and how to support and how to be there for his son. We will always be there for my grandson. But the problem now is that everything I taught my son he needed to be as a man is being challenged. He's a deadbeat dad. He has a bad credit score. He can't take care of his other kids. And all because of the fact that we found out 2 days before Christmas that my grandson is not my grandson. Is there any one person in this room that had a child that questioned on that day whether or not your child is yours? Were you happy to have a child? Or were you sitting back in the back of your mind saying, maybe I should get a paternity test, because just maybe in 2 years, this kid might not be mine? That is so wrong. DSHS has put a burden on my son that is not his, and it's unfair.
This is actually something that has been on my heart for a very long time. I did a presentation in law school on this very pervasive nature of paternity fraud. So thank you for your courage in coming and testifying today.
Since last year's failed Senate bill, I have been forced to pay another $10,200 in child support for a non-genetic child. This monthly payment has put our family in a low enough income to qualify my 3 children to be covered by Medicaid, which is an expense costing taxpayers and one that I could afford otherwise. Since September 2002, I have paid over $62,000 in child support, and if I'm forced to continue, I will pay another $25,000 before I'm free. It is time we allow DNA evidence to free victims of paternity fraud.
So you'll probably hear from DSHS today, who may exaggerate tales of this bill having negative implications to the state and its ability to qualify for 4D programs. The truth of the matter is far different, however. I'm submitting a letter from the Federal Commissioner of Support Enforcement that addresses the specific issue of paternity disestablishment. And it clearly states that while it is the state's responsibility to establish laws that qualify the 4D programs, it was never intended as a means to be used to extort money from innocent men who are victims of fraud. So even the federal commissioner encourages states to establish true genetic paternity whenever possible. There are 13 other states that have enacted similar reform, and there's no evidence to show that any of these states have been overly burdened or were unable to qualify for 4D programs.
We've been asked to address the DSHS's concern regarding this bill. The Washington DSHS has their mission statement posted prominently on their website, and it reads, "To transform lives. By continuing to garnish my wages for a child I have proved is not my son, they have effectively transformed my life into that of a miscreant or scofflaw, which is very disconcerting considering I have worked very hard to educate myself to be able to provide a stable home for my family without the benefit of public assistance." The DSHS also states that they are tied together by their values. At the top of their list of values is integrity and honesty. Turning a blind eye to paternity fraud is continuing to allow a lie to be perpetuated, is not honest, and only serves to impugn the integrity of the DSHS.
The opposition has proposed two issues to this bill that I would like to address. One, who will pay for these children if freedom is granted to these victims? And two, how will this affect adopted children and children born to reproductive medicine? This is simple. One, the biological dad can pay for these children, as no statute of limitations exists on the legal ability to reestablish paternity. And two, the bill specifically outlines that it would not qualify men who adopt and agree to reproductive medicine to be allowed to disestablish paternity. Lastly, I would like you all to consider the best interest of the natural and biological children of these men who continue to be financially deprived to pay for non-biological children. To deprive a man's biological children of necessities to pay for a non-biological children's necessities is a classic example of robbing Peter to pay Paul.
Currently, under the Uniform Parentage Act, even when filed within the first 4 years, the state can still deny your appeal under RCW 2626-535, which is one of the codes that this bill amends. It would no longer allow the court to deny your appeal when it's filed within that 4 years. Currently, the amount of time that you have that you can contest is 60 days. That's all.
My name is David Ward. I'm an attorney at Legal Voice, an organization that works to advance women's rights in the Northwest. One of the big things is our parentage laws are designed to be child-centered. They're designed to be focused on providing stability and certainty for children, in particular in knowing who their parents are and not having that be subject to dispute for their entire lives is important for stability and certainty for kids. So the 4-year limit on challenging paternity was viewed as a way to provide stability and maintain a child-centered parentage act. I guess I'd also just like to say one of the animating principles we have in our parentage laws is that genetics is not the only thing that makes a person a parent. And in fact, acting on a day-to-day basis as a parent is very important and makes a person a parent in the child's eyes. I just lost my dad 3 weeks ago, and I will say when I was sitting at his deathbed, I didn't care if I had a genetic relationship to him. I remembered everything he had done for me over the years, and that's what made him my dad.
My name is Wally McClure, and I'm the director for the Division of Child Support, part of DSHS. We have a couple of concerns about the bill. The first is that the bill as written right now says that one can present these genetic tests despite or regardless of fraud, duress, or material mistake of fact. The second thing that we're concerned about is the potential retroactivity of the support that's already been paid. The state plan requirement that guides us here is that child support, once it comes due, is a judgment, and that you can't retroactively modify that judgment. So we would hope that any language in the bill would be prospective rather than retroactive.
As a former paralegal, I'm here to support this bill as I've seen many cases of paternity fraud regarding men who have never even had a relationship with the mother. Some of those cases are lengthy separations and divorce under the presumption of fatherhood, where they are automatically in the divorce decree named the father. Then the other ones are often men who are just simply chosen because of their financial ability to provide and placed on the birth certificate. Currently, their only recourse is legal action if they're even properly notified that they've been named as the father. And in that case, even though the 2 years that was extended to 4 is claimed that can be remedied in court with DNA DNA evidence, often that doesn't happen because the appeals are denied. This is often complicated because it's prosecuted by the state as being in the best interest of the child that these fathers are made to pay this amount, when really they know full well it's in their best financial interest.
I'm a veteran of Iraq and Afghanistan. I'm 100% service-connected disabled. I live on a very limited income, and of that income, I am required to pay $250 a month to the Department of Social and Health Services for a child that is not mine, who I've proven is not mine through genetic testing, and who has a relationship with his biological father, actually lives with him. But the law actually stops the biological father from being able to get onto the birth certificate while it requires me to pay child support. He actually has to adopt his own son in order to become the father of the child. The courts have submitted to you guys a fiscal note that show that they predict there will be about 210 cases per year, which should indicate to you that this is more than just a problem facing a few people that are sitting here in this room. If I had been given the opportunity to continue on in this child's life that I'm paying child support for, I wouldn't try to change that to get myself removed from his life and to get myself removed from the obligation to pay child support. The only relationship that I have to him is the money that I pay. I think that it would just be fair that his father be able to be financially responsible along with having the benefit of the relationship with that child.
So I want to make sure I heard you right. So you're paying child support for a child who lives with his mother and his biological father?
Yes,
Is that what
sir.
I heard you say?
Yes, sir.
Okay. Thank you. I just wanted to be sure I heard that right.
Thank you. Thank you for your testimony. We have a number of people signed in not wishing to testify. In favor of the bill is Brandon Lyons. Opposed is Emily Murphy from the Children's Alliance, Steve Warning, Superior Court Judges Association, Melanie Smith from Wellspring Family Services, and Robin Zukowski from Columbia Legal Services.
Watch the companion video to this one, which shows highlights of how things played out during the hearings in 2016, which was the final year this legislation was attempted.